Welcome to the webinar, Department of Labor Conflicts of Interest Rule. What's the impact? My name is Jennifer Tamayo, and I am the marketing coordinator here at Multnomah Group. Before we get started, and before I introduce today's speaker, I would like to start with a few quick housekeeping items. First and foremost, thank you for taking time out of your day to join today's presentation. We hope you find the material useful in your practice. You will see that your line is muted. If you need assistance during the webinar, please use the question pane on the right-hand side of your screen to enter your communication, including any technical assistance needs with audio or visual. If you would like to ask a question, enter questions throughout the webinar using that same question pane on the right-hand side of the screen. There will be a question and answer session at the end of the webinar. Today's session will be recorded. You'll receive a copy of today's slides via email, along with a link to the recording of the session. Finally, there will be a short survey at the end of the webinar. Your feedback is important to us. We encourage you to take a moment at the end of the webinar to submit your feedback. Without any further delay, I would now like to hand over the presentation to one of our senior consultants, Bonnie Treichel, to get us started.
Thank you, Jennifer. As Jennifer mentioned, thank you once again for joining us and taking time out of your day to listen in to the webinar. The good news is that although this topic has literally dominated the headlines of the trade press since April 2015, the impact directly to plan sponsors is relatively low. So I guess that means we can be on and off this webinar in 5 minutes or less, right? Not really. In all seriousness, there are indirect impacts from this rule that affect many of the service providers to the plan, such as your record keeper, for example, which in turn indirectly affects the plan participants and plan sponsors such as yourself. So we might need a little longer than 5 minutes today. In addition, there are actually impacts on you directly as a plan sponsor. Thankfully, though, the impact to the plan sponsors from this rule, the DOL's conflict of interest rule, is substantially lower than the impact from the rollout of 408B2 or 404A5 that we dealt with a few years back. So with that being said, let's go ahead and get started with today's webinar. First, we'll take a look at the agenda for today. There's a few different ways that we could go about talking over this rule, a few different angles we could take given that this rule is so substantial in size. However, today we'll go ahead and just break it down by first talking about the overview of the rule. Where did it come from? What's the background? Who created the rule? Or in other words, what agency did it come from? And what are really the basic components of the rule? Then we'll talk about the anticipated industry impact. So who are the impacted players? Is it targeted at a specific audience? For example, targeted at plan sponsors, or targeted at advisors or brokers or vendors specifically? Then we'll spend some time and we'll break down the timeline for compliance. When do people have to be ready to make this rule work? And then finally at the end we'll have a short question and answer. And of course, if you're not able to stick around for the Q&A, no problem. You can always reach out to your Multnomah Group consultant for more information or additional questions. Keep in mind that most of what we're going to chat about today is geared toward plan sponsors. And that's important because the different action items that we'll go over and different takeaways from today's presentation, they would vary depending on what audience we're dealing with. So for example, plan sponsors have different action items than advisors or than record keepers or others in the industry. So just keep in mind that the main focus today is on plan sponsors. So this next slide that we'll take a brief look at just tells you a little bit about myself and why I might be qualified to talk to you about this subject matter. Thankfully, I came to Multnomah Group back in May, and before that I had the opportunity to work with several advisors and broker-dealers, and that gave me a little bit of different perspective on the industry impacts to this rule and how various players in the market are dealing with this rule and preparing for it. So that gives me a little bit different perspective of how plan sponsors can help work within the rule as well. So next, without further delay, we'll go ahead and just jump right into the rule itself and an overview of the actual components of the rule. And first, but before we actually get to the overview of the rule, we'll do a little bit of a level set of where does this rule actually come from. So first, I want to just make clear that we're talking about fiduciary in the context of the Department of Labor and ERISA, or rather the Employee Retirement Income Security Act of 1974. So we want to be very clear that this is different than the SEC's definition of fiduciary, or their potentially proposed definition of this universal fiduciary definition that's been contemplated under Dodd-Frank. So in the SEC context, there we're talking about maybe you as an individual and you going to an advisor, for example, with your stack of money, and you're going in your individual capacity. But here in today's webinar, what we're talking about is you with your plan sponsor hat on when you're working with the money of those participants in your plan. And so we're talking about fiduciary, you as a fiduciary, and the advisors you're working with as a fiduciary in that plan context. So we just want to keep that in mind throughout the entire webinar today, that we're under ERISA and the Department of Labor context when we're talking about this fiduciary rule. So now that we've kept that in mind, we'll go ahead and move on to the background of the rule. Where did this rule come from? So the Department of Labor's conflict of interest rule first was proposed back in 2010. And at the time this rule was proposed, it really just had one goal. And the goal of the rule was to cast a broad fiduciary net and to make more people fiduciaries. So it didn't include IRAs at the time. And if we stop and think about it for a minute, it's really, we want to keep in mind the goal of why would we want to make more people fiduciaries. As Timothy Hauser continues to reiterate, the reason we as the Department of Labor undertook this goal to revamp the rule in the first place was the belief that there was a significant problem in the retirement plan marketplace. And the basic idea, he said, was that you should be putting the customer's interest, not the advisor's interest, first. And so that's really why the Department of Labor set out on this goal to change the rule in the first place back in 2010. Unfortunately, there were some problems with the rule, really mechanically, so they ended up pulling back that 2010 proposal. However, they made changes to it, and then in 2015, in April 2015, the Department of Labor re-proposed that rule. And at that time, we saw that there were really two overarching goals. So again, the Department of Labor had the goal to bring more people under this fiduciary umbrella or fiduciary net, again, sticking with that idea that we want to put the customer or the investor or the plan's interest first, putting them ahead of the advisor's interest. So that same goal was out there. But they also extended that goal, and they began to include individual retirement accounts, or IRAs, and that became under the scope of the rule. So we saw that proposed again April 2015. That being said, it was met with a lot of industry opposition, and I think that's probably something that a lot of you are familiar with and began to hear about last summer or maybe even last spring. So at that time, there was an extended comment period, many days of hearings in August 2015, and it became a really politically divisive issue with both sides of the aisle taking sides on this rule. We also then saw the final rule came out a year later in April 2016. So with that being said, we'll go ahead and move on to what you're seeing on the slide, which is really, what are the basic components of the rule? And keep in mind when we saw it come out in April 2016, there were over 1,000 pages in the Federal Register. So there's multiple components to the rule. It's not just the one section in the Federal Register. There's multiple sections that were published all at the same time back in April. So first, we have the guts of the rule itself, which are the revised definition of fiduciary. So we'll get into that a little bit further on the next slide here. But within the rule, we have this broad definition of the term fiduciary, and then you see that there's a lot of activities that are carved out, or excluded from, rather, that definition. So for example, we see that education, some of you are likely familiar with that. Education doesn't constitute advice, and so therefore it's something that doesn't give rise to fiduciary status under the new rules. Then second, there's a series of revisions to, and there's also some new prohibited transaction exemptions, or PTEs, as you may hear them referred to as well. So keep in mind that a prohibited transaction exemption is only needed if there's a prohibited transaction. So there's a lot of these components of the new rule package that are only applicable to specific situations. And some of them, they really don't apply directly to plan sponsors. So as a plan sponsor, you're not going to say, oh yeah, I need to use this PTE because I have a prohibited transaction. That being said, as a plan sponsor, you may become familiar with some of these prohibited transaction exemptions because you'll be the recipient, for example, of some of the disclosures or documentation that results from some of the prohibited transaction exemptions. So one of them that we'll talk about a little bit later is the best interest contract exemption. And likely in your individual capacity, if you are doing a rollover at some point, or even in your capacity as a plan sponsor, you very likely may receive some of the disclosures or documentation that results from the best interest contract exemption. So again, you don't have to create these disclosures because of this new rule, but you may receive some of the disclosures or documentation that results from the new rule. So finally, the last component that's not even on the slide is that you will likely see, and the DOL has already started doing this, some additional guidance from the Department of Labor that will come out piecemeal over time. So for example, at the beginning of this month, we saw the department come out with additional guidance with respect to insurance companies and discretion, as well as some grammatical changes to the new rule. The department has also indicated that they will continue additional guidance with respect to operationally some of the components of the new rule. So just like we've seen over the last 40 years with ERISA, we'll continue to see additional guidance from the Department of Labor over time as to how this new rule applies, and we'll see that on a going forward basis. So with that being said, I think we'll move on to actually looking at this new definition of fiduciary. And to start with that, we'll go ahead and turn to ERISA Section 3, and we'll take a look at the 21st definition. So as I mentioned, the new rule, the first big component of it is changing, and the genesis of where this all starts is changing the definition or the test for the definition of fiduciary. How does one become a fiduciary? So again, we're going to take a look at ERISA. This is Section 3, and we're turning to the 21st definition. So to become a fiduciary, a person is a fiduciary if they do one of these three things. If they first exercise discretion over the management of the plan or plan assets, or alternatively, if they render investment advice to the plan or to the plan's participants for a fee, or if they have discretionary authority in the administration of the plan. So many of you as plan sponsors, you're probably pretty familiar with this third component, has discretionary authority in the administration of the plan. So for example, if you are responsible for making decisions with respect to loans, or if you are signing that 5500, that would be this third bullet point. You're exercising your discretion in the administration of the plan. So you'd be a fiduciary, and that's based on that third bullet point. But what about the second bullet point? If you have a relationship with Multnomah Group, for example, that would be, by virtue of this second bullet point, Multnomah Group would be a fiduciary because we're rendering investment advice to the plan, and we're doing that for compensation. So for a firm like Multnomah Group, we are a fiduciary. This is under the current rule. We're a fiduciary today, and we'll be a fiduciary even after the rule because we're rendering investment advice to the plan or plan participant. We're doing it to the plan, and we're doing that for compensation. So that's a look at the current Section 321, but to determine if you meet that second bullet point, there's a 5-part test, and that's under today's current rule. So we'll go ahead and flip to the next slide, and we'll take a look at what the current test is. So to meet that second bullet point that we saw on the last, the last slide, we currently have a 5-part test, and this is not under the new rule that's going to take place. This is under today's rules. So the current 5-part test, this is an and. So if you meet all 5 of these prongs, then you'll be a fiduciary. This is a functional test. You'll be a fiduciary under Section 321 that we looked at on the last slide. Now, what we found in practice in the industry today is that some practitioners, they use this 5-part test to say, hey, I'm not a fiduciary. So one of the common ways that they do that is by saying, I don't meet on a regular basis with the plan. I only give one-time advice, not regular advice, so I'm not a fiduciary because I don't meet all 5 prongs. So in practice, what I'm saying is that a lot of times you'll find the 5-part test is used as a way to get around fiduciary status. So let's step back for a minute and think about why is it that someone might say, I don't want to be a fiduciary? Well, there's definitely some reasons to not want to be a fiduciary. For example, number one, if you're a fiduciary, you have to have a prudent process in place. So as a plan sponsor, you understand prudent process because you have to have a prudent process. And if you're a Multnomah Group client, we talk about that in a lot of your committee meetings. However, for some brokers that were not a fiduciary before the final fiduciary rule came out, that's a big leap to start, with the notion that, hey, on a going forward basis, I've now got to have a prudent process in place for all of these activities. Second, think about co-fiduciary liability. So if you're a fiduciary, you now have to think about co-fiduciary liability. So again, under ERISA, a fiduciary should be aware of others who serve as fiduciaries to the same plan, because all fiduciaries have potential liability for the act of their co-fiduciaries. For example, if a fiduciary knowingly participates in another fiduciary's breach of responsibility, conceals the breach, or does not act to correct it, that fiduciary is also going to be liable. So that's another reason why someone in the past may have said, hey, I don't want to be a fiduciary, or perhaps their supervising firm said, hey, we don't want you to be a fiduciary. So finally, think about prohibited transactions. We mentioned that a few moments ago. If you're a fiduciary, there's a certain list of things under the code that you can't do. It's that list of no-nos or prohibited transactions. And if you do those things, then you either have to have an exemption or a PTE, or you'll be subject to penalties. So again, that's another reason why a broker, for example, or their supervising firm in the past might have said, we don't want you to be a fiduciary. So that's why, some things to think about why in the past some people may have used this 5-part test to avoid being a fiduciary. Now, keep in mind that if you have a relationship with a firm such as Multnomah Group, they were a fiduciary in the past, and they'll continue to be a fiduciary in the future, and it doesn't change your relationship with an organization such as Multnomah Group. But going forward, we'll go ahead and flip to the next slide and take a look at the replacement test. So the 5-part test that we just looked at, that will be no more. Instead, on a going forward basis, there will be a new test, a very, very broad test. And so the test that you're seeing on the screen now will replace the 5-part test. And if you meet the test on the screen now, that will make you a fiduciary, or rather, that will make a financial professional a fiduciary under Section 321 on a going forward basis once this final rule is applicable. So, what does that mean? That means it will be covered advice, which will then give rise to fiduciary status if you're rendering investment advice for a fee, and that can be a fee that's received directly or indirectly, which is per an agreement, or it can just be based on an understanding, or where communication is specifically directed to either a plan or a participant, and where investment advice constitutes recommendations as to how to invest assets, or it can apply to IRAs as well. So that's that second goal that we said was added into the 2015 proposal, or recommendations as to who should invest the assets. So that's where those solicitor programs or referral programs are going to come into play as well. So again, it's a really, really broad test. It's not a 5-prong test anymore where you can just omit one of the prongs and get out of fiduciary status, but it's getting at that DOL goal of being able to bring a lot more people under this fiduciary umbrella, so that most financial professionals are going to be under the umbrella of having to put the interest first of the client, the interest first of the plan or the participant. And that's really how this final test is trying to go about that goal of putting the interest first of others, not the advisor or financial professional. So a few more kind of guideposts about what this test really means. Keep in mind that the more individually tailored a communication is, the more likely the communication is to be considered a recommendation. The DOL did clarify that something like hire me, so for example, if Multnomah Group is telling you why we're so great, if I tell you, hey, you know, Bonnie's such a great advisor, this is why you should hire me to, you know, do XYZ service for you, that's just marketing, and that's not going to constitute advice. Likewise, in that same kind of exception or exclusion, general communications, media announcements such as if I'm on TV and I'm telling you through a general TV announcement about something financially related, that's not going to be advice either. That's just going to be a general communication. So overall, we could spend a lot of time, for example, the whole webinar talking about how broad this test is, but overall, keep in mind that many communications that were once non-fiduciary are now going to become fiduciary in nature on a going forward basis. So with that being said, I think we'll go ahead and move on to some of the specific activities that the DOL did specifically identify as exceptions or exclusions that are not going to be considered advice under the final rule. So some of these are going to have a little bit more applicability to plan sponsors than others. One that I think is going to be particularly more important to plan sponsors is going to be the first one, employees to plan sponsors. And that's identified as number 2 on the list on the screen. So this exclusion for employees to plan sponsors, it's an exclusion from the definition, and it's meant to cover those in the company's payroll, accounting, human resources, maybe the financial department, who are going to be routinely preparing reports and recommendations for the company and other named fiduciaries of the plan. So these would be people working in day-to-day roles. These individuals, they're not going to be considered investment advice fiduciaries. So the preamble gives some examples. For example, an employee in the financial department who's preparing a report for the CFO and then communicates directly with a named fiduciary for the plan. That's not going to be an investment advice fiduciary, provided that that individual doesn't receive additional compensation for the preparation of that report. If for some weird reason that individual did receive additional compensation specifically for providing that report, then that additional compensation would then result in it being investment advice, but provided that there's no additional compensation there, then that's not advice. The next one we're going to move on to is the investment education one, number 5. Now, if you have not listened to anything the entire time, and if you don't plan on listening to anything else the rest of the webinar, I would suggest that maybe this is the one to listen to. This is the one place in the entire final rule where plan sponsors are actually given an affirmative responsibility. So here, in investment education, will maintain its status as education as opposed to advice, very similar to the way it was outlined in the 2015 proposal. And then it's also very similar for those of you familiar with Interpretive Bulletin 96-1. So they'll still have the 4 different like safe harbors, as some of you are likely familiar, which include the following. The first, plan information, which includes descriptions of the investments or plan alternatives without specifically recommending particular investments or strategies, general financial information, investment and retirement information, as well as then asset allocation models and interactive investment materials. So this is where it gets a little bit different from the 2015 proposal. The final rule did establish different rules for education provided to IRAs and to plans. So with respect to asset allocation models and interactive investment materials, if the education is provided to an IRA, specific product or investment alternatives may not be identified. However, if the education is provided to the plan, you can go ahead and identify those specific funds as long as certain conditions are met. And that makes sense, I think, because when it's provided to the plan, you've got an intermediary there. If it's to an IRA, there's no intermediary there. So I think that makes some sense. And here's where the important part is. For plan sponsors, the education provision of the final rule comes with this heightened responsibility or affirmative responsibility I was telling you about. So in addition to the plan sponsor's responsibility to monitor service providers on an ongoing basis, you also now must periodically monitor the asset allocation models and the interactive investment materials that are made available to participants as part of an education program. So the preamble to the final rule, and I'm going to pause for a minute because I don't think I've really mentioned what the preamble is. So for those of you who haven't taken a look as part of your bed night reading to the actual preamble itself, or the rule itself, the preamble really is like the good stuff. So the preamble has all of the actual description and the meaning of what everything really means in the rule. So the rule itself is a lot of like legalese, and that's at the very end of the document. But the good stuff is at the beginning, and that's where all of the examples and explanations are. And that's at the very beginning, and that's called the preamble. So if you take a look at the Federal Register, look at the beginning part, and that's where all the pages and pages and length are. But that's really where you can understand what the rule is all about. So back to the meat of the presentation. So as the DOL describes in the preamble, the ongoing evaluation should include, and this is the ongoing evaluation by the plan sponsor, it should include an assessment of whether the models and materials are unbiased and not designed to influence investment decisions toward particular investments that result in higher fees or compensation being paid toward parties that provide investments or investment-related services. So that's the responsibility of the plan sponsor to make that evaluation when they're making those educational materials available. So I think that's something that look to guidance from your consultant, from your ERISA counsel, and I think that's something that we'll continue to see more guidance come out over time, and we'll certainly be watching that and monitoring it and providing additional guidance over time as well. So you can go back to not listening now. No, I'm kidding. So continuing on, a couple other quick areas we want to touch on this slide before we move on to the rest. the platform provider exception. Why is that one important? It's important for plan sponsors that rely on their record keeper to help with the selection and monitoring of fund lineup. So for example, a third-party record keeper will still be able to send a representative perhaps to your committee meetings and provide a report that includes funds which are available and that align with the specific IPS for the plan or other investment guidelines, so long as specific requirements are met. So one side note I would just ask you to keep in mind is that one of the things we're doing today is covering a lot of ground, and we're covering a lot of ground at a pretty high level. You may keep in mind that these are just the broad exceptions and the broad rules. You'll definitely want to consult with your ERISA counsel, a knowledgeable retirement plan advisor, to get more specifics and to talk about how these things apply directly to your plan, because we're definitely just hitting the high notes today. So just keep that in mind as we kind of buzz through some of these things. The last one on this page I want to hit on is the independent fiduciary exception. So this exception applies to larger plans. The final rule creates an exception for communications with sophisticated investors that are presumed to know that a financial professional may not be acting in their best interest. So again, that's for larger plans. So the independent fiduciary exception allows the advisor to receive fees in connection with products it sells to a plan, provided that a fiduciary with financial expertise is making the decision on behalf of the plan to purchase a product. And then the last one that I wanted to touch on was just the general communications, and we really, I think, pretty much already hit that. That's, again, if broad media communications via the TV, the hire me, that sort of thing. So I think that really hits on the activities that are considered not advice. So far we've had the chance to talk about what is the change in the definition of fiduciary, what are the activities carved out from there, and then the next thing we'll talk about is moving on to what is kind of the big new prohibited transaction exemption. And again, there's a lot of different changes to the exemptions under the new rule package, but the one that we're going to talk about today, which is the most controversial, or was the most controversial for most of the industry groups, is the best interest contract exemption. So one of the things we want to keep in mind, again, this is a prohibited transaction exemption, and it was created because under the new rule, many more retirement plan professionals who have never before been fiduciaries are now going to become fiduciaries. So as a result, the way they were being compensated has to change, or alternatively, they will need this new exemption, or an exemption, probably this exemption, to be compensated. So this exemption only comes up if there's a prohibited transaction, and a common prohibited transaction is unlevel compensation. So let's take a step back. For an RIA, or a registered investment advisor, like Multnomah Group, that charges a flat level fee. So for example, what is a flat level fee? A flat level fee would be if Multnomah Group charges, let's, for easy sake, say we charge $100 per year, and we charge that for 5 years, $100 per year. And flat level fee means it doesn't matter how many times the plan changes investments. It doesn't matter how those investments do. Whatever the investments are, doesn't matter. It's $100 per year. That would be a flat level fee. On the other hand, there's other people who more traditionally have been like brokers, and they charge unlevel compensation. So it's more transactional-based fees. So for those transactional-based fees, the new proposed rule, or excuse me, the new final rule, it is basically squarely targeting those types of compensation models and saying, hey, you've got to change those models. That doesn't work. Whereas those level flat compensation models, they don't have to change. So that's really where the best interest contract exemption one of the ways it's going to come into play is for those transactional-based models that need to change. Other ways it's going to come into play would be things like IRA rollovers. That's another place where you're going to end up with an unlevel compensation situation, and you would need, you as a financial professional would need a best interest contract exemption. So as a plan sponsor, you don't have to create a best interest contract, but you'll likely be on the receiving end of some of these agreements in the ways that we just talked about and kind of talked on earlier in the presentation. So what is the best interest contract exemption? There's a few different flavors of the best interest contract exemption. So it's going to vary based upon whether it's an ERISA plan, a non-ERISA plan, an IRA, or it's dealing with proprietary products. The best interest contract exemption changed a little bit from the 2015 proposal to the final rule. In fact, it changed fairly substantially to make it a little bit more workable. But the gist of it is the same. It just operationally works a little bit different depending on the context. What it is, though, the overarching theme is the same. And the theme is that it creates an agreement between the financial institution, not the investor, and the investor, in which the financial institution agrees that it will serve as a fiduciary and will adhere to the best interest standard of care. So in the contract, the financial institution agrees to several things. First, to acknowledge fiduciary status. Second, to the impartial conduct standard, which means a couple of things, and this is kind of a new concept. First, that the advisor does what's in the best interest of the client. So that's a blending of the duty of loyalty and prudence under ERISA and trust law. Also, that compensation is not in excess of that which would be reasonable. Next, that no statements are going to be materially misleading. Also, there's a series of warranties. So there must be a warranty in the contract that the financial institution has adopted and will comply with policies and procedures that are reasonably and prudently designed to ensure that the advisors adhere to the impartial conduct standards that we just talked about. A warranty that doesn't allow advisors to rely on quotas or incentives. So that's going back again to that DOL concept that we're going to put the client first, not the advisor first. So the advisor can't be incentivized by, some sort of incentive program. And then finally, that there's policies and procedures that identify and document material conflicts of interest. So again, all of this is going to that notion that we're going to be putting the client first and not the advisor or the firm first. So again, that's just a really high overview of the best interest contract exemption. But with that being said, I think we'll move on to what I think is a really critical aspect, are who are the impacted parties, and then more importantly after that we'll talk briefly about what are the actual action items for plan sponsors to take before we wrap up today. So to an extent, I think, everyone is impacted in the retirement plan marketplace by the DOL rule to some extent, even if it's only an indirect impact. For example, I think that even plan participants will likely be impacted. The products available to plan participants are being impacted, as well as the pricing. We see, as a result of the best interest contract exemption, and even, for example, prohibited transaction exemptions such as 8424, which we didn't talk about today, that will likely have a change on annuity products, for example. So given the change in the way annuity products will be sold under the new rule, there will likely be a change in the way these products are now available. And we've already even started to see some of that. So for example, companies have started making announcements about the innovation in these new products. So for example, Jackson National, they're a variable annuity sales leader, and they're developing their first fee-based VA. So I think some of the experts out there say, that's maybe what the future of the product line looks like in the qualified market. So that's just one example of product innovation in the space. But I think, with respect to pricing, for example, if you think of all of the legal and compliance costs as a result of the new rule, there's got to be some pricing change as a result for participants. Someone's got to pay for it. RIAs, or registered investment advisors. I think that RIAs are probably the group that is the least impacted. So fee-based RIAs like Multnomah Group that have traditionally serviced retirement plans, they're the least impacted, I would guess, because the service model has to be only really minimally changed, if at all. I think really the impact that they face is just by the shifting landscape of others in the marketplace, such as the changing products that we just discussed, for example. Brokers and their broker-dealers. I think this group was hit the hardest, particularly small and mid-sized broker-dealers that don't have the resources like big wirehouses. For BDs, entire business model shifts are transforming. Decisions such as, are we going to allow brokers that have never been a fiduciary to now become a fiduciary? What is our new value proposition? What do our new agreements look like? What are our policies and procedures? How are we going to train, supervise? Are we going to implement the best interest contract exemption? What's our risk and liabilities? How are we going to get compensated? I think those are all questions that are being dealt with in a relatively short time frame. So I think, for broker-dealers, these were pretty big transforming shifts. Service providers. I think service providers are, dealing with some pretty tough decisions and changes too. So think about your record keepers. A lot of record keepers provide educational services to your plan participants. They also provide support related to rollovers. So during your communications with these vendors, I would ask, ask directly things like, how are these types of services, like rollover support, educational services, how will they be handled next year after the final rule? Will these services continue to be available? Will they be advice? Will they continue to be the same cost? For example, if the provider currently provides on-site education to participants, ask if they will have any change in the service after the final rule next year. Everyone that was not previously under the fiduciary umbrella that is now suddenly under the fiduciary umbrella, they're undergoing some sort of change, some sort of systems development. It's certainly a change and something that they're all considering. So with that being said, let's really move on to what's most important to you as a plan sponsor. What are the action items for plan sponsors? Keeping in mind that this is certainly not an exhaustive list, but some items for consideration. And certainly feel free to reach out to your Multnomah Group consultant and discuss further and discuss specifically how these items impact your plan directly. So first and foremost, you want to make sure you know who are the plan's covered service providers. Before you can really examine your relationships with these providers, you need to understand who you have relationships with, like what you did with 408B2, really. It's really the same exercise and something you should be doing on an ongoing basis. Next, you want to understand how the rule impacts these entities. Was this firm a fiduciary before the rule? Will this firm be a fiduciary after the rule? Again, here you may just want to ask the providers, have that candid conversation, as I was suggesting on the last slide. These firms, given the timing of all of this, these firms should be examining these changes under the rule right now, and I think really most of these firms are. So, if they're not, and if you're talking to a provider or one of your covered service providers and they can't tell you how the new rule affects them, that might be a red flag in and of itself. So definitely just ask the questions. Then, you want to take a look at how this rule affects you as a plan sponsor and your obligations to participants. So for example, we talked about your responsibility with respect to educational materials. Also, you have obligations to prudently select and monitor service providers. So if you are currently working with a broker, for example, who, let's say, they're going to become a fiduciary under the new rule, and let's say come 2 or 3 years from now, you never get an updated agreement, you never get new disclosures from this broker, then arguably, let's consider, are you doing your job to prudently select and monitor this broker if the new rules pass, you know, come next April, you never get a new disclosure document for the next 3 years, and this broker is clearly now, but they've never let you know otherwise, and they've never updated their documents under the new rule. I would argue that maybe you're not doing a good job selecting and monitoring the service provider if they've never fulfilled their obligations and you've never asked them any differently. So just think about that and what your responsibility would be to ask them those questions and to monitor them accordingly. Finally, you want to prepare yourself, your committee, and potentially participants for new disclosure documents and novel agreements. For example, we've talked about, you know, those documents with respect to rollovers and education materials. Think about, you know, you may have noticed that this rule began to get some traction with national headlines. So, you know, your participants may ask you about it, and you want to be prepared to answer their questions. So just think about how you want to field those questions, and you certainly, at a minimum, want to talk to your committee members about it and make sure that everyone's aware of, you know, the types of material that we've talked about today. Certainly don't need to, you know, give them an exhaustive rundown of the rule. They don't need to read all 1,000 pages, but making sure they get the high points and the types of material we've covered today. So we'll go ahead and turn to the final portion of today's presentation, which is just a quick rundown on the timeline. So the effective date was June 7th, 2016. The applicability date, that's what we're really concerned about. In the proposal, there was only an 8-month window from the final rule to the applicability date. Fortunately, there was a bit of a reprieve, and the department came back and said, you know what, we'll give a year. So there was a year for the industry to really get up to speed, get all of the systems built for compliance. So the real date to be aware of is April 10th, 2017. That's when firms have to start complying. And then the other key date is January 1st, 2018. And that's the date that all of the best interest contract documents and disclosures will start getting rolled out, because that's kind of the second wave of compliance when the best interest contract exemption, that's when that compliance date begins. So by basically January 1, 2018, that's when the rule fully takes effect, and you'll start to see everything in action. So with that being said, I think I'll go ahead and turn it back over to Jennifer for some concluding remarks.
Once again, we thank you for tuning into the webinar today. If you have any questions, once again, please feel free to use the window on the right-hand side of the screen to enter any questions you may have, and we will answer those questions with the remaining time we have today. In addition, as you exit the webinar, please take a moment to take the survey, as your feedback is appreciated and valued. Finally, be sure to pull out your calendar, mark down Tuesday, August 30th at 10 a.m. Pacific for the next webinar, which will be a regulatory update. During that time, Bonnie will again join us to walk you through a regulatory overview of those items of interest from the Department of Labor and IRS during the past year. We'll discuss items including changes to the Form 5500, litigation trends, retirement readiness, and much more. And now I will turn it back over to Bonnie for questions.
Great, thank you, Jennifer. It looks like we've got a couple of questions coming in now. The first question, let's see. I've heard that the first question is with respect to lawsuits and kind of the likelihood of success on those lawsuits. So the question, I've heard that there are some lawsuits that have been filed against this rule. Can you speak about that? Perfect, so that's a great question, and I apologize we didn't get to that on the webinar. So absolutely, I believe there's 5 different lawsuits pending. And these lawsuits have been fast-tracked, more so than a typical lawsuit that drags on and on. And that being said, these lawsuits have, in my opinion, a very high bar to overcome because Basically, there's a lot of deference given to the agency in these types of cases. So even though industry opponents of the rule, like some of the broker-dealers and trade groups, they've put a lot of money into these lawsuits. The chance of success, again, in my opinion, is very low. So I think, the advice that I've heard from attorneys and consultants in the industry is really, and I believe this is really the only option because of the short time frame for compliance, is that the industry is moving ahead and preparing, building the technology and tools and compliance aspects that are required for the compliance with the rule in order to be ready for next April. So I think, yes, there's lawsuits out there. Yes, they could succeed. They are being fast-tracked. I know the motions for summary judgment have been filed, and they're pretty scathing, but I think that the rule's moving forward and everyone in the industry is getting prepared. So to the extent that plan sponsors need to be taking action, I think it's time to take action and get ready and not wait around for lawsuits. But I think that is a great question and a great point to make. Looks like we have another question here. Does this rule apply to 403B plans? Great question, particularly given a lot of the 403B relationships that Multnomah Group has. So, to clarify, if you are an ERISA-covered 403B plan, then yes, this rule covers ERISA-covered 403B plans. So, it does apply to ERISA-covered plans. But for non-ERISA-covered 403B plans, these plans and these participants would be excluded from much of the fiduciary rules protections, except where an advisor makes the recommendation to roll over those funds into an IRA. So the recommendation to an IRA, that would be covered under the new rule because of the IRA piece, not because of the plan piece. So it's that the recommendation into the IRA that would then be covered. The more complicated matter that I think I would reserve for another day, maybe with respect to some of those legacy individual contracts that exist in 403B plans. I think that would be another issue for consideration. So something to keep in mind there. Well, perfect. I think that's about all we have time for today. We once again appreciate everyone tuning in, and we look forward to you joining again on August 30th for a regulatory update.